afternoon.
My lords, my lady, good afternoon. I was just finishing off the fourth ground.
Yes.
And as I've indicated, I don't think I will need very much longer at all. So I just shown my lords and my lady the Dutch case, and what we see from the analysis in that case, which we pray and aid, is that the dominant components of the mark in issue in this case are consistent across the variations permitted within the scope of the mark. And what that means is that the consumer is able to recall the same sign from an origin perspective. Obviously doesn't mean that the variations are visually identical, they're not, but they all convey the same origin message. And that might be a useful way of providing a dividing line between a mark which has permissible variations on the one hand, and a registration which may be said to, in fact, comprise multiple signs on the other. I think this was a question my Lord Justice Arnold put to me this morning, which is, how do you decide between a mark that's got a multiplicity of different signs on the one hand, or permissible variations of the same sign on the other? And the answer may well lie in the origin function, as I think I explained this morning, because the variations, the point of the variations isn't the difference in visual appearance between them per se. It's about if or to what extent those variations impact on the origin message. And the vice of the learned judge's analysis, we say in paragraph 192 of her judgment, is that she just proceeds on the assumption that the visual differences, the difference in appearance, are significant. But what she doesn't go on and undertake is a proper analysis as to the relevance, if any, of that visual difference.
Are you accepting, for the purpose of the appeal, that the differences are significant?
No, precisely, absolutely not.
No,
So,
I'm just talking as factually, visually. I appreciate you have an argument about their significance and,
yes,
and what people would understand from them.
yes.
But is it your case that, as it were, a sleeve-long stripe and a 1/3 sleeve stripe, wherever it happens to be, that the judge's conclusion that those were visually significantly different is wrong?
My submission is that I accept that they are visually different.
Well, visually, I said significantly different.
Yes, that's where I part company with the proposition my Lord is putting to me.
Well, maybe significant has a number of meanings, but if we were to say that they are clearly visually different, is that your complaint, or is your complaint different to that?
The complaint is that merely having a visual difference in and of itself is not enough. That can't be the test. And one of the reasons it can't be the test is because the judge herself accepted that variation within the scope of a sign is permissible per se. And it follows as a matter of logic. Once you accept variation per se is permissible, the variety will bring about visual difference.
There may be questions of degree, but if the judge had found, as I think she has, that there's a major difference between a full or a 1/3, wherever it's placed, mark. If I'm trying to understand whether you're querying her factual observation that there's a major difference. Is that what you're contesting?
Well, it's the word major that I mean, she uses the word significant. I think my Lord has used the words.
Well, I'm trying to get away from significant because it might mean it signifies something for something else. But
yes.
I mean, speaking for myself, if something is on one sleeve 9 inches long or 2.5 foot long, strikes me as that's a major difference.
So it depends.
In the clothing world,
it's obviously a difference in size. I can't deny that, and obviously looks different as a consequence that one is bigger than the other. But the point I'm putting to my lords and my lady is our submission is it's got to be a relevant difference, and it can only be relevant in one of two ways, as I've explained already this morning. The first is because the difference means that the scope of the mark is no longer clear, and the second is because the difference prevents the mark from conveying a single origin message.
Can I ask about the logic that you were suggesting? Because you suggested that there was a flaw in the judge's logic, and I want to ask about that. Because the test for identity of signs, as you will know, not everybody in court will know, is that signs are identical for trademark purposes if the differences between them would go unnoticed by the average consumer. So you can have differences, they're not the same, and yet they are regarded as, in law, identical if they would, differences would not be noticed by the average consumer.
Yes.
So why does the fact that the judge accepts that the fact that there can be differences is not fatal logically undermine her assessment as to the effect of the extent of the differences to which my lord has just drawn attention?
I'm sorry, my lord. Just want to make sure I'm answering the right question. I'm struggling to understand my lord's question. I'm so sorry. My lord is putting to me that the judge accepts that there are differences visually.
No. You said that there was a logical contradiction
Yes.
between her acceptance that it was permissible to have variation and her conclusion that the extent of the variations here was too great. And I'm trying to see whether there is a logical gap, as you submitted, given that you can have identity of signs where the differences are not noticed by the average consumer.
Yeah, and the reason I say there's a logical gap is because her judgment at 192 merely focuses on the visual difference. And she doesn't engage in any kind of analysis as to whether, and if so, why, that visual difference is a meaningful one for the purpose
Surely
of
that's
the question.
precisely what she does in the 194 and 195.
But the problem is, at 195, she does address the question of origin at 195, but that's predicated on her erroneous view that the reader doesn't know what the mark consists of, and as from which she considers that there's a confusion as to the scope of the mark. But as we've discussed this morning at some length, that view is based on paragraph 193, where we say, fundamentally flawed in reaching the view that you can change the position of the mark. So she thinks you can change the position of the mark, so it's not limited to the outer lateral surface, and it can go anywhere around
Given
the
you've
arm.
returned yet again to 193, can I ask you this question? As
Yeah.
far as I can see, she doesn't repeat that remark in relation to any of the other 5. So let's assume that the fatal flaw in her analysis on this mark
Yes.
is what she says in 193. Where do you stand on the other 5?
Well, it's the point that I touched on this morning with my lord, where we had understood that it was something that she relies on, because for each of the other marks, she says, I repeat the points I've made in respect to the tracksuit top mark 588. So my lord is absolutely right that she doesn't say in terms with the other marks. You can also change the position so that it's on the underside or the other side of the leg.
It's more than that, because she goes on in relation to the other marks. She doesn't just say apply the above. She specifies the sort of variations that can occur. And in relation to the other marks, none of the variations she mentioned relate to the position as being other than on the outer side of the garment. So I think I would endorse for my own part, endorse what my lord is saying.
Yes. Well, I'm not sure I can take the point any further. Like I say, we had understood her concluding paragraph. Every time she analyses any of the other marks, she says she repeats all the other points that she's made in respect of the tracksuit top mark. And so because that's an unqualified statement, we had understood it to be all of the points, including the one that she makes on 193, which is once you understand that the pictorial representation is only an example, it no longer anchors or limits the position of where the stripes can be. But I have to accept, because it's correct, that she doesn't address that point expressly in her reasoning of the other marks. But like I say, because she concludes with saying, I rely on all of the same points, it's there nonetheless.
And how does that work for the vest marks?
Well, that's a good question, my lord. But it's...
It can't possibly work, can it?
Well, there's no reason why you can't move the position of the mark on her analysis to left of the seam, right of the seam, further along. It would still be vertical, but it would just
Where
be
does
anywhere
she say
around the
any of
garment.
that? Where does she say any of that?
She doesn't in terms. My lord is absolutely right. But all I can point to, as I think I've done already, is paragraph 235, last sentence on page 132, and this is in the context of the vest mark. I repeat all of the other points I have made in respect of tracksuit top 588.
And so we are to understand from that, on your submission, that includes putting it on the underside of the sleeve of a garment which has no sleeve.
No, of course not. I'm not saying that. What I'm saying is that she applies the same reasoning, which is the reasoning she puts in paragraph 193, which is once you understand the pictorial representation only to be an example, you are no longer limited by the position of the stripes in that pictorial example. And you can put the stripes anywhere.
Yes, so it could be, for example, on the front of the vest.
Yes.
Yes.
Yeah. And so that's the problem with her analysis of the origin message in 195. It's predicated on a wrong understanding of the interpretation of the mark. What she should have done is analyze the origin message by reference to the images in para 191, just as the Dutch court did. And if she had undertaken that analysis, she would have appreciated, as we submitted in the court below, that in respect of the same stripes in the same position, namely the lateral outer surface for that mark.
Since you've referred to 235, can I just ask a last question on
Yes.
this? Because what she says there is, I disagree with Adidas that taking them as a whole, the relevant public receive a single sign with a limited degree of variation relating to the length of the stripes. So she's focusing on length of stripes, isn't she? She says it's of different forms.
Well, one of the reasons she's disagreeing with it, based on the reasoning back in 193, is because the variation isn't just limited to the length. You can, on her logic, also change the position, and that's part of the problem.
Variations she's contemplating are those discussed in 234. She says the available permutations, and they're all about the length.
Well, on our argument, they are all about the length, but this is the point I'm saying, is that you can't tell, because at 193, which is a reasoning she says applies across the board, she's departed company from the limits of the graphical representation as a whole, the combination of the picture and the words, and said that you can change the position of where the stripes are from a position that's not in the pictorial representation.
Okay.
Just for completeness, it's only in the context of the question of the origin message that we referred to the real world use that Adidas make of the stripes of varying length. So this is the point about whether or not we are arguing we're relying on acquired distinctive character. We're not arguing that acquired distinctive character is of any primary relevance to the question of registrability. The law is clear in relation to that question that it's not. What we're saying is that evidence is useful by way of a cross-check because it is of usefulness and comfort to see that the way, in fact, that Adidas uses the mark in practice is one which is consistent with the view that the consumer sees the same sign. And that is the extent of that part of our argument.
Yes, but unless one can rely upon acquired distinctiveness, that tells you nothing, because that is equally consistent with the proposition the consumer always sees the mark as being decorative in its various different forms, and it's just different types of decoration.
Well, that might be right, but like I say, it's and that's why we only put it at the level of a cross-check or secondary evidence as a way of the court asking itself rhetorically, is my conclusion that I consider the variations to be variations that are consistent with the sign conveying the same origin message, a conclusion that makes sense? And the answer to that rhetorical question is, well, yes, it does make sense, because you can see that's what in fact happens, as evidenced by the conclusion the judge reaches on acquired distinctive character. Unless I can help my lords and my lady any further.
No, well, thank you very much indeed, Ms. May, and to Mr. Kay for those submissions. Yes, Mr. Roberts.
May it please the court, I should say that Learned Junior and I have carefully considered whether, in accordance with the recent guidance on junior advocacy, whether there is a self-contained point that could usefully be disentangled from the others, but we've reluctantly concluded not. So I'm afraid, my lady, my lords, you'll only be hearing from me and not from my junior in this appeal.
Well, I'm sure that Mr. Cronin wants to do any gown tugging, that he'll be able to do that.
The forest of post-it notes will no doubt flow behind this stowaway.
Yes.
The structure of my submissions to the court, to my lady and to my lords, are as follows, very broadly speaking, and subject to being hurried along at any point. First of all, an introduction and very brief summary of the standard review and the implications of Mullen & Friends acceptance, that this is an evaluative assessment. Then some observations on the core issues as we see them in the appeal. Then some recap on the legal framework, perhaps filling in some of the, with respect, gaps that have been outlined in relation to the authorities. And then finally addressing each of the grounds in sequence. I propose simply to do them ground 1, ground 2, ground 3, ground 4, rather than trying to follow my learned friends sequence. My lady, my lords, there was a suggestion, the only thing that I think has caused any fluttering in the dovecotes on this side of the court, that maybe my side had forsworn or never argued any point in relation to Mattel and Zinger or the multiplicity of signs point. The fluttering, of course, because we don't have all of the trial skeletons or trial transcripts here, but my lady, my lords, I'm content I can thoroughly skewer that point just on the documents that we do have. Could I please ask the court, first of all, to look at Core Bundle tab 13. Actually, no, first of all, even though it's out of sequence, tab 16, page 344. This is the key passage in our pleading back to the allegation of infringement. Paragraph 9 at the bottom. it's denied that each of the Adidas trademarks is represented with sufficient clarity and precision. It's further denied that the particulars claim failed to provide reasons for the allegation that the Adidas marks constitute an impermissible multitude of signs, the particulars of claim set out in respect of each of the Adidas marks, and so on. So that was how it was pleaded. That was, in case there was any doubt about that, that was subject of a Part 18 request, which is at tab 13. If I could ask the court to look at page 279 at the bottom. The request comes in, please explain what is meant by an impermissible multitude of signs, and in relation to the meaning of impermissible multitude of signs, the claimants, that's us, would draw to the defendant's attention the law in relation to registrability as expressed in cases such as J.W. Spears and Zinger and Nestle and Cadbury. So, and there's even a reference to what Sir John Mummery says. So I fail to see how we could have made that any clearer that the point was live on the pleadings. We only have a homeopathic trace of the trial skeletons in the bundles, I'm afraid. It comes in on a different point, and it's in the supplemental bundle. But even from that, I think you can see, from, at least from the subtitle, that it was a live issue at trial. It's supplemental bundle tab 10, and we literally have 2 pages from our closing submissions. But the court will there see above paragraph 39 the underlined subheading, the description broadens or is inconsistent with the graphic representation / impermissible multitude of signs. TB maintains what was said in opening on this issue. Now, we can go and get the other skeletons if necessary, my lady, my lords, but we say that we're surprised at the suggestion that we never ran the Mattel and Zinger point. I'm sorry, I keep calling it the Mattel and Zinger point. I was instructed as James Mellors Jr. in the Court of Appeal. I wasn't in front of my lord, Mr. Justice Arnold, as he then was. And by the time it got to trial, it was referred to as Mattel and Zinger, but due to things that don't matter. So, my lords, my lady, we say that that is, with respect, not a good point to say that we never argued multitude of signs. And indeed, there are other parts of the judgment that show the.
Well, what we'll do, I think, is wait and see what, if anything, is said in reply on this point. If it's challenged, then you may need to produce further documents or have the opportunity to do so, and if it isn't, then it'll go away.
Well, I'm answering as best I can on the basis of the materials before me that could be looked through over the short adjournment. So first of all, as regards the summary of the appeal and the decision below, we respectfully invite this court to affirm the judge's finding in relation to invalidity. The judge correctly concluded that each of the 6 registrations at issue failed to satisfy this fundamental legal requirement.
When you say this fundamental legal requirement, which do you say she found it failed to comply with?
The first question and the second question, the multiplicity of signs and clarity and precision. And that is, if at times it's rolled up in the judge's analysis, frankly, that's no more than was done in Heidelberger when it was talked about the sign being capable of perceived unambiguously and uniformly. It seems to me that uniformly is a multitude of signs point and unambiguously is a clarity and precision point. But the judge's ruling was that it did not correspond to a single, clear, precise, and objectively ascertainable sign. And we say that embraces both sides of it. As I detect the way that the appeal's been put, and I may be wrong, it seems that first point, multiplicity of signs, is really a feature of ground 4 in the appeal, and grounds 1 to 3 are more related to clarity and precision, the second question. But we say that we are the beneficiaries of finding in relation to both as a result of those paragraphs which have been pored over at length. and we say that both of them should be upheld. My lady, my lords, the judge's determination that the marks were invalid, as we've seen, involved a close evaluative assessment of the specific scope and ambiguity in the marks drafting. And I've recorded that my learned friend accepted that it was an evaluative assessment, and therefore we are into the territory of a multifactorial assessment and the need to identify a gap in the logic, a flaw, or some other material factor which undermines the cogency of the conclusions that the judge reached. And we say that no such flaw has been identified under any of the grounds. In fact, very little fire has been directed at the judge's analysis of the law. It's all been in relation to the application of the law to the facts, and in particular that passage in relation to the second tracksuit top mark. I say the second because there was another tracksuit top mark which was also rendered in, which was also adjudged to be invalid. That was the 808 mark, and some of the I would remind the court respectfully of the fact that actually that comes first, and quite a lot of the logic flows through from the analysis of 808 to the 508 and the 095 marks. And we do say it is perhaps telling that Adidas have only appealed in relation to 6 of those invalidations. We do say that that is indicative of a lack of any systemic failure, any architectural defect, if I can put it in that way, of the judge's analysis of the cases, or indeed application of the cases. In effect, what my learned friend is asking this court to do is to open up the whole can of worms and pour through each individual worm and carry out the learned judge's assessment over again. We say that is not the appropriate basis on which to mount or succeed in an appeal before this court. We say that her judgment was careful and nuanced. The high threshold which is set for intervention by this court has not been met, but even better, my lords, my lady, she got it right for the right reasons. It's not just that she didn't get it wrong enough, she got it right. So the core issue is whether those 6 registrations comply with the first 2 requirements under section 1.1. So multiplicity of signs and clarity and precision. And as I think my learned friend has accepted, that has nothing to do with how famous the Adidas brand is or how widely the 3 stripes have been used. I didn't entirely follow the cross-check that my learned friend was urging upon this court, but it sounded a lot like the heretical paella which Mr. Silverleaf tried to serve up to the Court of Appeal in the Mattel and Zinger case, and which Sir John Mummery said was unpalatable. I think, if anything, my learned friend is watering down Mr. Silverleaf's paella. Equally, 12 years later and watered down, in my respectful submission, it is no more palatable to the current members of the Court of Appeal. That is because, what is the sign? Is there a sign? And is it capable of graphic representation? Are antecedent questions to be asked before you get into distinctiveness, before you get into that aspect, the more traditional aspects of the origin function. I think the pithiest way that first requirement has been put is by Sir John Mummery and by Mr. Justice Arnold, as your lordship then was, in the Zinger case. Is it a sign? You know, the indefinite article is doing quite a lot of work there. As I say, in Heidelberger, paragraph 31, it's about being perceived uniformly.
Well, if you're going to make that point, one has to be a bit careful, because one of the things that is often not appreciated is that changed over time. So when we look at Article 2, the first council directive, it says a sign. But by the time you get through to the subsequent revisions, the language changes and it says signs plural.
Well, I think it's been accepted we are in a time warp in this case because the priority date of the marks is 2003.
Yeah.
So.
But on the other hand, it suggests that one shouldn't place too much weight on the indefinite article in the original version of the legislation.
Well, Your Lordship has the point. In fact, Your Lordship, in an even earlier judicial incarnation, analysed a very similar topic in the first authority we have in the bundles, the Sony case, to do with series marks. I don't know if Your Lordship recognise.
I'm struggling to understand the relevance of series marks to our discussion.
Well, absolutely, and Comic Enterprises has sort of undercut the idea that they all have to be that each of the marks in the series has to be part of the same sign. It said you've in effect got a bundle of signs under the same mark. But what Your Lordship said, as I'm sure you, for the benefit of the other members of the court, it's Authority Bundle 1, page 8, paragraph 20 of the Sony decision. I hope it's not necessary to get into the interstices of series marks, because I'm really just relying on this statement of principle, which in my respectful submission hasn't been doubted and is correct. It's a sort of buttressing reasoning that was put forward at the back end of paragraph 20. And this really feeds into why the competent authorities are relevant people for the purposes of these assessments. Because what's said here is there must be, for the purposes of double identity, so that is a conflict under section 5.1 or section 10.1 of the 1994 Act. It says there is a likelihood of confusion is presumed, or a conflict is presumed, where you have identity of mark and identity of goods and services. And therefore, it must be possible to work out whether something is identical to an earlier sign. And what the appointed person in this case said was that these provisions, I'm now reading from the around about the second half of paragraph 20, these provisions presuppose a single exercise of comparison between the earlier trademark and the later trademark to ascertain whether or not they're identical. It would not, I place emphasis on this sentence, it would not be consistent with the scheme of the legislation for the earlier trademark to comprise multiple candidates for comparison capable of giving rise to different answers to the question, identical or not. My lord, we say that my lords, my lady, we say that the same principle should apply to the position marks before this court. If when the court, when the competent authorities, when competitors, when members of the public look at the pictorial representation and the text accompanying it, if they are unable to ascertain whether or not what they're actually comparing with in the earlier mark, because there are multiple candidates, such that you could end up with a different answer to the question, is the later mark or is the putative infringement identical to it? Because it might be identical to the mark using the top third of the sleeve, not even getting into whether you count the shoulder as being part of the sleeve, as opposed to the entire sleeve. And we say that that is the vice, one of the vices of the multiplicity of signs. If you can't tell whether or not it's identical, then in those circumstances, it is not a sign. You are looking at multiple signs and an impermissible multiplicity of signs. And there is a debate which, in my respectful submission, the judge navigated delicately and flawlessly about whether there need to be an infinite number of variations in order for it to be an impermissible multiplicity, or whether it's okay if there's a finite number. The judge said it didn't really matter whether there was an infinite number or whether there were 10 or 15. The fact is, if they are different contenders for the double identity comparison, that is sufficient to say it is not a sign. It is not a single sign. It is an attempt to register a sort of, as we put it in our skeleton, a Swiss Army trademark with all sorts of different blades and tools attached. Buy one, get 10 free or something. We say that is not possible with this kind of trademark. And my learned friend has made some sort of overarching submissions about the nature of a position mark. My Lord, Lord Justice Arnold, we've not been able to track down the WIPO definitions or debates that your Lordship alluded to. I will continue looking. But my submission is very simple. It's that
more importantly, perhaps for our purposes, would you quibble with Ms. May's definition of a position mark, which struck me as a helpful one?
Let me make sure I recall it correctly. It was that there is a sign and a position, and that those are the two different elements of it.
Yeah, one has to be careful with the word sign for obvious reasons. But what she said, and I'm paraphrasing rather than quoting verbatim, but the essence of it was, it's the combination of a visual element and the position of that element on the goods.
Yes, and we would agree with that. And obviously our answer to that in a nutshell is, and in this case, both of those seem to be able to vary, because the appearance of the sign varies as you go from 1/3 to full length, and the position varies as well. So we say you've got variability along both of the axes of this position mark. We put it very simply at paragraph 5 of our skeleton, and this is an attempt to, I hope we are singing in harmony with my Lord Justice Arnold, based on an observation your Lordship made earlier this morning about word marks. We say that a word-only mark must clearly and precisely specify a word, and a position mark must clearly specify a position. And just as you can't have a variable word mark, you can't have a wild card word mark, if the court understands what I mean by that. Sometimes when you search for files on your hard drive, you might use an asterisk or a question mark to stand for a wild card. You couldn't register a formula which could give rise to any number of different words. If I was to register the mark Adidas, but add a textual description which said a word in which 1/3 or more of the letters are A, that would map onto the word Adidas, but it would also cover all sorts of other words like appeal. So we say that where there is that sort of variation and multiplicity such that you can't tell how the comparison can work for the purposes of double identity, as we put it in the skeleton, the center point of the circumference, where section 10.2, 10.3 are the circumference of protection around that center point of double identity, we say that the mark is for it does not satisfy that first question because it is a multiplicity of signs. And there may be some grey areas around, the sorts of LTJ diffusion type where the differences will go unnoticed, but we say that's more of a question for the canons of comparison than it is for the definition of the mark to begin with.
Yeah, well, that was the question I went on to deal with in Sony, paragraph 21 and following.
Yes, quite so. Well, in fact, as your Lordship may have seen from the judgment below, we made the submission to the learned judge that that should be the test for what was a permissible multitude of signs. We said that.
Can you give us the reference in the judgment?
Yes. It's paragraph 124, my lord. That's where she recorded it. And as I think is common ground in this appeal, the judge rejected that as a sort of bright line test in terms of the what was necessary to define a sign.
So that's 130.
Yes. And that may explain some of the way in which the reasoning proceeds in the judgment, because she took
And
the
to
view
be clear, you've got no respondent's notice seeking to revive that.
no respondents notice seeking to rely on that. Indeed, we've accepted in our skeleton. We are here to support the judge. We're not trying to reheat yesterday's leftovers. My lord, then the second aspect is clarity and precision. And Malone and Friend has made submissions on the court on the basis of Glaxo, and indeed we worked quite a lot of the way through the Glaxo decision, but we didn't really get to the punchline in the analysis. And I'm going to come to Glaxo in a minute, but the sin in Glaxo is not just if the text is inconsistent with the picture, it's also if it gives rise to a puzzle, if it causes you to scratch your head, if it introduces ambiguity about what the mark is actually covering. And in the present case, my own friend's right in the sense that it is clear that the pictorial representation is an example that falls within the text. So in that sense, it's not inconsistent. It's just, if I can put it this way in terms of set theory, it is one element of the set. It is an example in layman's terms. And that really was the vice in Glaxo, because there the court will recall the depiction of the sort of the circular inhaler with the light purple and the dark purple, and we can see it in colour in the Babek decision at the back. And it was put by counsel for Glaxo that, well, just take the representation as it is. In fact, the two can be read together perfectly consistently, because it's just restricted to the precise depiction of that inhaler. And the court said no. When you are faced with a broader, more general description and a specific pictorial representation, such that people would be scratching their heads, it would present a puzzle, it introduces ambiguity. In those circumstances, that the mark is not capable of graphic representation because it is not clearly and precisely specified. And that's a different question. That's the second question, not the first question. Or I forget what we call them, elements or points.
I tend to call them conditions first.
Conditions.
And second.
Okay.
First, second
That
conditions.
is a-
requirements, whatever.
A second condition. And we say that the judge says that 1/3 or more wording and the taking as a whole. Malone Friend keeps saying that the judge allowed the text to trump the image, or allowed the don't think she accused the judge. She accused us of being anxious pedants, according to the language of the Babek case, looking for problems, looking for ambiguities where there are none. In my submission, the judge, according to perfectly orthodox principles, said that the text gave rise to doubt as to the subject matter and the scope of the pictorial representation. And we do say that in those circumstances, she was right not only to find that there were an unacceptable or impermissible multitude of signs, but also that the mark had not been clearly and precisely claimed within the graphical representation.
I'm going to ask you the same question I asked Ms. May, which is how does one distinguish between a multiplicity of signs on the one hand and a single sign subject to permissible variation on the other hand?
Well,
particularly in circumstances where you're not seeking to revive the LTJ test.
Exactly. Well, I thought that was quite a neat way of doing it, but
yes. So how does one?
How does one? It's an evaluative assessment, and of course it's possible to fall foul of both tests. I mean, whether it's possible to fall foul of one and not the other, whether there can be. I think yes, there can always be something which is clearly and precisely claiming a multitude of an impermissible multitude of signs, and that's where you run into what I said earlier about the whether you see the same sign. I mean, Curley puts it. I'm not quite sure where Curley got that language from, but they say it's all about whether you look at the variations and you see the same sign. And that's why my learned friend has been saying they are variations on a sign as opposed to a multiplicity of signs. We and the judge say it's a multiplicity of signs. If and insofar as that's an evaluative assessment, then we say that the judge's impression, based on all the evidence that she received, should be preferred and upheld.
Could I just ask you how does the analysis work? Let's suppose the mark that was claimed was not the one with which we're concerned with, but was one which provided for the 3 stripes down the length of the sleeve, but with variability so that it might be up to 5 centimeters shorter either at the top or the bottom of the mark.
I see. So a sort of manufacturing tolerance on the length of the plus or minus 5 centimeters.
For design impact maybe, or whatever it might be. So you take the length of the sleeve, not including the shoulder, not including the cuff, and it was a single 3 stripe down the entire length of the arm, or up to 5 centimeters shorter either at the top or at the bottom. How might that have played out compared to what we have here?
Well, I'm sure we would still be saying it was that is an example of something which has been clearly and precisely specified. If it tells you everything about the dimensions,
well, it tells you
down
that
to the
you're
length.
going to see somebody with a sleeve that has a line the full length or very slightly less than the full length.
Yes.
Of up to no more than 10 centimeters short of the full length. And inevitably covering both forearm and upper arm and the elbow.
Yes. Something
of that sort. Would that, on an analysis, lead to a different outcome in probability?
The honest answer is I haven't thought about it. I can see that there would be. It is at least an attempt to get a single visually significant sign within error bars, if I can put it in those terms, but we say that is quite fundamentally different from if one looks at the 10 examples.
I've suggested it because it's fundamentally different from what we appear to have in the present case. But I'm wondering, in a sense, what possible objection there could be to a mark of that kind.
Yes. Well, it may be that simply it would. The graphic representation would be relied upon as a single point of reference, and then 5 centimeters here or there would just be regarded as going unnoticed by the average consumer when it comes to the comparison test being applied for the purpose of identity. So the judge's reasoning was that not all variation is sufficient to render the mark invalid, but the judge took the view, and we support her view, that the degree of variation in this case was such that it was an impermissible multiplicity of signs, that the significance of I'm giving evidence now, and that I mustn't do that, but that something that in a sort of in the position where I have my cuff here on counsel's gown, it gives a very different impression. I might look more like an airline pilot if I had.
Seen with the different alternatives shown in the judgment.
It is. It also come across better on the transcript rather than me gesticulating towards my arm. It's above all.
I take your case to be that illustrates that this was a multiplicity of signs.
Yes.
Or bundle 126.
And yes, and with the greatest respect to my mind, that's all I really need to show my lady and my lords, and unless you are satisfied that that these differences are properly to be regarded as minor, and that in fact they are all the same sign and there's no significant visual difference between them.
Can I just on that? The judge used the term minor variations, and my lord talked about the opposite, major.
Mm-hmm.
We're getting away from the word substantial deliberately.
Yes.
You've talked about the going unnoticed, which is a test in determining whether a mark and sign is identical. But that is not the test applied by the judge.
No, that was rejected by the judge.
You're not seeking to disturb any part of the judge's reasoning. So is your case then just consistent with what the judge said? These are not minor variations.
Absolutely. We say these are not minor variations.
End of it.
That was first of all, we say she's correct. Secondly, we say in any event, it's an evaluative decision. I mean, the poor judge was besieged with endless evidence about the significance of stripes in military contexts and police contexts and sporting contexts. So if anyone knew, was sufficiently well educated about the significance of stripes on different parts of sleeves and legs and everything else, it was the judge. And we say that from the appellate standard point of view, that the judge's assessment should not be disturbed. And we invite you, frankly, to endorse it. In terms of the, I was going to address the court about strategic ambiguity and why these kinds of marks, ambiguous marks, can give an unfair competitive advantage. I infer from some of the observations made from bench to bar this morning that I don't need to labour that point. Of course, a broad, nebulous trademark can grant an unfair advantage to the proprietor of that trademark when it comes to asserting infringement on the one hand, and when it comes to defending a validity attack on the other. It's the same as with patents. You always want the patents to be as narrow as possible on the validity analysis, and then as expansive as possible when it comes to infringement. My lady, my lords, when it comes to the legal framework, again, I don't want to retread old ground or labour too much, but we do say that it's important to bear in mind the three perspectives that are identified in the authorities when it comes to why it is important to have certainty about the scope of a trademark. And as my learned friend has correctly identified, there must be certainty for the authorities, so that's the registration authorities. There must be certainty for economic operators, which generally speaking is competitors. I suppose it might also be licensees, but also for the public in terms of ensuring that the mark functions correctly for the consumer. And we say that all of these point towards the need to define precisely the subject matter so that the subject matter can be appreciated when it comes to relative rights conflicts, when it comes to infringement, licensing, and when it comes to performing the origin function. But as I say, without trespassing on the territory of acquired distinctive character, that is something which that is a separate and discrete question. And when I think my own friend criticises the judge for failing to apply the consideration as to whether the average consumer can perceive and recall a particular combination and thereby repeat a purchase. I think in my own friend Skeleton, that certainly seemed to be put in heretical terms in terms of look at all the ways we've used the Adidas mark. There was a little bit of rowing back that somehow it should instead be just a cross-check. But in my submission, the judge did apply that test in terms at the end of paragraph 195. And it seemed to me, at least at one point, that the only criticism was that the judge considered it at 195 rather than at 192, which does seem to be, well, my side is being accused of being anxious pedants. Touche. Yes, I think I should probably develop a little bit more the fact that the description must clarify rather than confuse, because, as I say, my learned friend correctly noted from Glaxo, and I think also Heidelberger, that the text mustn't be inconsistent with the pictorial representation, but there is a second limb to it. It mustn't confuse. It must serve to clarify it. It cannot give rise to doubts as to the subject matter and scope of the graphic representation. And we say that is what the judge has done in relation to the clarity and precision second requirement.
Is it really the last of that? It mustn't give rise to doubt. I mean, presumably, if the words in the end didn't really add anything to the picture, it would be neither here nor there. They don't have to positively add as long as they don't create doubt.
That's right. That's right.
Because I think it was said earlier, a picture alone could be sufficient.
Well, we none of us would be here, or at least we'd be doing different things here, if there had been no text accompanying these images.
Yes,
It would have been.
I'm making a much more simple point. It is possible, is it not, to register a trademark with the picture only?
Yes, it's very common.
So the text doesn't need to positively add to it, but it mustn't confuse or create doubt, as I understand.
Yes, it mustn't be inconsistent or give rise to doubt. That's how it's put, I think, in Heidelberger, and was picked up in Red Bull and Glaxo in those terms. And if you can also apply for a picture, and then for whatever reason have text that just exactly describes what you see. It's put in one of the cases, what you see is what you get, WYSIWYG. And again, that no problem there, because the two are congruent. You've got the description, you've got the two hand in glove operating. It's where there's a note of.
But let's get real here. I mean, you've pointed to what you call strategic ambiguity. I mean, yeah, there's no doubt as to why trademark applicants do this. They do it so as to broaden the scope of protection. And the argument against you is that there's nothing wrong with that. But yeah, it is Adidas's own case that what's in the pictures is merely an example.
Quite so.
And that's why they don't just have the pictures. The words are put in deliberately to broaden the ambit of the registration, and I don't think you argue or could argue that it's, as it were, an impermissible objective. The question is rather, have they, in attempting to broaden the scope of their registration, have they actually introduced confusion which is inimical to the purpose of it?
Yes, again, we're on second requirement now. The first requirement, even if there's no confusion, you can overclaim. You can very clearly claim, the everything.
You could clearly claim 1,000 different signs, yes.
Yes, every word beginning with A. So when it comes to this, yes, absolutely. And I think my Lord Justice Arnold, one of the first questions was, well, to clarify, you don't need to put in a description, and Adidas chose to put in the description and frame it in the way they did, and we infer it was to expand the scope of the pictorial representation. And in fact, Adidas is being slightly more open about it than in a number of other cases. So in Glaxo, the proprietor, when it came to the validity assessment, said, "Well, no, it's just that particular representation that we're seeking to register." I think also in the Babek case,
Well, that was only on appeal. By the time you got to that stage, they'd offered, in the course of various pieces of litigation, strikingly different interpretations of their own registration.
Yes, I mean, look, and I don't want to trespass too much on it. If any members of this panel are going to be hearing it next week, and I have no involvement in that case, but it did seem to me that it was an attempt, at any rate, just to describe the figurative mark, as opposed to, with a colour claim in a convention. I mean, that's one of the reasons you use that text box with a figurative mark, is to claim particular colours. And it seems to me that's what they were trying to do in Babek. My learned friend called it Babek. I must confess, when I first saw it, I wondered whether it was some sort of Sumerian ruler or something. But I then read the judgment and saw that it's kebab backwards. So I think it does have to be Babek rather than Babek.
Well, thank you for that enlightenment.
Well, there we go. Don't say you didn't learn something from my submissions. Therefore, we say that this is the danger of the text, that it expands the graphic, because left to its own devices, one would have assumed that pictorial representation was a full-length sleeve, which has a particular, we say, distinctive visual impact. In Glaxo Wellcome, I think it was actually put even more broadly. The Lord Justice Kitchen, as he then was, said that the public...
Shall we have a look at that?
Yes. It's tab 3. So he says that the public be left in a state of complete uncertainty.
Paragraph 80.
Yes, your lordship's ahead of me. And the uncertainty arose because of this verbal description being put in much more general terms than the pictorial representation. So,
but that's in circumstances where there's been 3 possible interpretations of the registration.
yes,
One is just what you see in the picture.
spikes and all.
Yeah. And then it's the second one is essentially just what you see in the words. And the third is even more abstract.
Yes, anything. And anything in 2 different shades of purple. And that degree of uncertainty meant that a member of the public would doubt whether a narrow interpretation of the mark was correct. And
So let me see if I've understood that point. Do I understand that what you're pointing to there is the part in paragraph 80 where Lord Justice Kitchen says, Mr. House admits, and I'm inclined to agree, that the third possible interpretation is the best, or at any rate the least bad, for it provides a way of reconciling the NID code, the pictorial representation of verbal description. And it says, well, it's far from clear. So even though he inclines to agree that that's the best interpretation, the lack of clarity of it is sufficient to say it doesn't comply with the requisite criteria.
Lord, yes, it's put in various different ways, but it's a puzzle. It leaves the relevant. I'm still baffled by the number of people who normally I'm just used to the average consumer. Here we have to consider all of these, competent authorities and everyone else as well for obvious reasons. But at least some of them, possibly all of them, would be scratching their heads as to what the scope of protection actually was.
This is to put the contrary argument, this just strikes me as much less extreme than what was being considered in Glaxo.
I mean, possibly it depends which of the one's considering. It's certainly less extreme than it was in Dyson, and Dyson was a very strange
and I
one.
may be making a point that this is all a question of degree, and it comes back to the
Evaluative assessment. Yeah.
Evaluative assessment. I completely understand that. I'm just trying to understand your submission.
Mm-hmm.
So, in what respect are consumers scratching their heads here?
As to we can look at those specific representations in the judgment, again focusing on the track. And there are all sorts of points that can be made on the vest marks because, for example, one of the vest marks is just registered in relation to upper garments, so without any restrictions to sleeves or anything. So there are all sorts of other puzzles. But looking specifically at the tracksuit marks, there are the 10 different variations which are highlighted at the top of page 126. I say 10 different. I actually think 2 of them are the same. I think the top left and the penultimate ones are, at least to my eye, same. And the way I tried to work these out is that the cancellation division divided the arm from the collar to cuff up into 6 segments and tried to sort of work out the permutations and combinations. So I think there should mathematically be 15 different permutations, and we've got 9 of them, of which 2 are represented twice. But we say there are puzzles about the significance of the shoulder. I mean, the text talks about the sleeve. It rather depends how the garment is constructed as to whether the shoulder and the sleeve are to be regarded as part of the same thing. My learned friend confidently says the cuff doesn't count, but again, that's just taking the cue from the pictorial representation. There's nothing to tell us in the text that is regarded as the case, and it may well be in other forms of garment, like the one I'm wearing, that the cuff would be included as part of the length of the sleeve.
Well, yes, but that's not what the judge found.
No, that's not what the judge found. But
So, I mean, we're sticking with what the judge found.
Okay.
These mean.
There's still the questions of short or long sleeves. There is the question the judge did identify about whether it's on the inside or the outside of the sleeve. But where it is clear that only one element of the set, which is described in the text, has been depicted, it causes all of the relevant people, the public, the economic operators, the competent authorities, to scratch their heads and say, well, what other things can change then? And for my learned friend says, well, it only says that the stripes can vary. Well, that presupposes the correctness that the pictorial representation is shaping the text, and that you can draw all sorts of cues from that rather than just reading the two together. So we say that the judge was correct in those circumstances to regard it as unclear, that there was significant. I think she did put it in terms of confusion. Yes, what paragraph 196? The mark will not always be perceived unambiguously or uniformly, and it follows the authorities and the public will be left in a state of confusion as to the nature and the scope of the sign. This would give Adidas an unfair competitive advantage. I am being a pedant now, but when the cancellation division said there's not an infinite number of variations, they're clearly not mathematicians, because there's an infinite set of numbers between 0 and 1, so there are definitely an infinite number of, technically an infinite number of positions that the stripes can be, but that's not a submission that carries any legal weight, just mathematical rigour.
Yes, you said earlier should be 15, but that's not.
Well,
I mean,
yeah, so it's just
that's
15 on the
different
basis that
anyway.
if you divide it up into 6, you've got five different places to put a 2 unit.
Yeah, I
4,
get that.
3,
and
2, 1.
I get that, but that's, yeah.
Yeah. So we say we're very happy with the judges, which is actually the cancellation division's depictions of the variations. We say that that alone is sufficient basis for the judge's decision and sufficient basis to uphold her reasoning. We say that those are self-evidently visually different, and it's back to I come back to the Sonny test and what the appointed person, in fact, several of the appointed persons said about if they're a graphically, visually different sign, how do you work out whether it's identical? But again, that's the more of a first requirement rather than a second requirement point. Right, I think I should turn to the specific grounds now after those, the long run up to the crease on general core principles. The first ground of appeal is, or what was ground 1A, I think it's now become ground 1, is misapplication of Dyson, and we deal with that at paragraphs 37 to 53 of our skeleton. And I'm still finding this a little bit with respect to elusive, because the ground itself alleges that the judge interpreted Dyson as requiring the automatic invalidation of any mark that allows for additional unrepresented signs or any variations that are not depicted. We say that's not what the judge said, and in any event, what the judge did say is entirely consistent with Dyson and the English cases which have followed it since, with in particular with Glaxo. So first of all, we say the judge rejected this sort of bright line principle that if there is any possibility of a variation that's not depicted, then that fails. It's in the very same section where the judge rejected our LTJ diffusion submission. So the judge was prepared to treat it as possible that there could be a degree of variation, provided you are looking at the variations of the same sign rather than a multiplicity of different signs, and provided that it's clearly and precisely set out. So she recognised that some variations permissible, provided the variations embraced are adequately identified, and she recognised that the extent of permissible variation will depend on the market, on the specific mark. So it's
paragraph reference again.
yes, this is. I don't have a note in my submissions at this point. 135, my own friend's telling me. I'm sure that's correct. Yes. The degree of precision required in any case, and thus the extent of the authorities, and thus the extent of the permissible variations will depend on the nature of the mark itself. and she refers back to the fact that a number of the preceding authorities were about colour marks, which, as we've seen, are quite difficult to objectively specify because colours appear differently on computer screens and on the page, etc. And the judge looked through all 16 marks which were put forward for the purposes of the infringement allegations, and some of those, the marks which were adjudged to be valid, did contain a degree of permissible variation. We refer to the shoe mark in our skeleton, which was upheld. So again, it really can't be right that the judge applied a hardline principle on the basis of Dyson. We say that the judge approached Dyson perfectly correctly, and her invalidation of the 6 marks that are the subject of appeal was based not on the existence of unrepresented or multiple signs, but the finding that the registrations failed to define a single clear sign capable of being uniformly and unambiguously interpreted. And it's true to say, as I think my lady, Lady Justice Falk, put it to me, in the context of the Glaxo case, that the Dyson case had potentially much broader, a much greater degree of artistic freedom in what these things could look like. And Dyson's a very curious case because as
it's more fundamental. It's not really a trademark at all.
Well, it's a concept.
Exactly. So the concentrating on the facts of Dyson,
Yes, well, also there's a very curious feature of Dyson. There are lots of curious features about Dyson, but as my Lord Justice Arnold has reminded us all, you couldn't actually tell from the description and the pictorial representation that there was this claim to the universe containing clear collection bins. It's only because it was common ground between the parties that was treated as self-evidently so when it went off to the European Court. So it's curious for a number of reasons, but we say that we're not saying that the judge below invalidated the 6 marks because they were merely a concept. It's to do with the fact that it's a non-specific subject matter, and it is that there is an unfair competitive advantage to be gained from an ambiguous trademark registration. And we say the judge correctly found that this wording 1/3 or more gave rise to an indeterminacy that amounted to a claim over a wide range of different appearances, maybe not as wide as in the Dyson case itself, but that was the nature of the abuse which was condemned in Dyson. And that was what the judge took from Dyson, and we say the judge correctly took that from Dyson. But in any event, one could derive the same propositions from the perhaps more closely analogous situation in the Glaxo and Sandoz case. Once again, it's all to do with clarity and precision as opposed to ambiguity, which arises as a result of the graphical representation as a whole. And I mean that in the technical sense, the text and the picture introducing confusion. So the judge didn't apply, we say, that absolute interpretation of Dyson. So the judge applied the correct, nuanced approach to Dyson, which is to take into account the scope of the mark as one of the relevant considerations, and in those circumstances, the fact that there are that you're only being given an example in the pictorial representation, and the fact that there are other pictorial representations presumably out there which aren't being depicted is, we say, surely and self-evidently a factor when it comes to the, in fact, both of the requirements of the first and the second requirement of the test for registration. And any suggestion that the judge was not allowed to take that into account, we say is just wrong, because one sees it in all the cases. The ground 2, or ground 1B as it was, seems to boil down to a disagreement with the judge's quantitative or qualitative assessment of the degree of variation which results from the wording 1/3 or more. Adidas contends the judge overstated the resultant range of possible signs or exaggerated the degree of multiplicity. Again, as with all of my submissions, my first and foremost submission is the judge got it right. But even if we're wrong about this, we say it's clearly an evaluative assessment, and this ground can't succeed if it just boils down to a challenge to an evaluative finding without identifying a legal error that vitiates her ultimate conclusion. Indeed, the judge herself, as we've noted in the skeleton, said it wasn't about counting the number of variations, not in itself a helpful or informative indicator as to invalidity. That was where she said you don't need to have an infinite number of variations in order for it to be objectionable. So it's not down to a head count of permutations, but the objective failure of the registration document itself to comply with section 1.1. Whether the variations were adequately identified by the registration. The judge concluded that it didn't satisfy it. The drafting was inadequate because the public would perceive a sign which is intended to cover a wide variety of different forms, none of which is readily ascertainable from the words and illustrations used. That's 195, which we've been poring over. So even if this court were persuaded that the judge has overstated the complexity or the volume of, has counted the number of permutations incorrectly, it's a concession that emphatically we do not make. We say that disagreement would not touch the core, would not establish the core legal error that would need to be identified. We say that the problem is a fundamental flaw in clarity in the trademark registrations, which prevents the registration from identifying a single unambiguous and uniform sign.
What do you say about paragraph 193, which was the principal focus of the attack?
(193) and does your lordship mean in particular the last sentence of 193? Well, 193 is, I mean, it was identified in the for a slightly different purpose in my own friend's skeleton. We say that that sentence could quite easily be deleted. It's not a critical path element of reasoning, and we say in any event it's self-evidently correct. As a sort of self-contained observation, it's correct. And it's not a gap in the logic. It is merely an illustration of the degree of variability and the types of confusion which can arise. But there are already, if I can put it this way without meaning to be flippant, Adidas have got bigger problems with these registrations, which are identified in the other paragraphs of the judgment. And we say that if my own friend is really having to take out the tweezers and the scalpel and start, criticising, as I think my Lord Justice Peter Jackson put it, if the judge doesn't need to score 100% in this exam. And we say in those circumstances the judge clearly got it right, and even if there's something wrong with that last sentence, it's not something that vitiates the conclusions that she reached. Moving on to the third ground, ground 1C. This is dealt with in our skeleton quite shortly, paragraph 62 to 64. The allegation seems to be that the requirements of clarity and precision were muddled up with a requirement that any variations in the mark must be depicted. And therefore, as we suggested in the skeleton, it seems a bit like a sort of a collocation of the previous two grounds. We say that this is a mischaracterization of the judge's reasoning. She was correctly applying the paramount requirement of clarity and precision, the second requirement, as we've been calling it, regarding the definition of the sign, and constantly and diligently taking the two together. In fact, we say if anyone is seeking to place undue emphasis on one of the two elements of the graphic representation, it's Adidas. They're the ones who are saying, no. I know the text looks broad, but you can hedge it around with the pictorial representation. I'm not sure how that is consistent with saying it's just an example. Examples can't confine the superset. So we say that the judge's conclusions were 100% compliant with the decisions of this court, Nestle and Mattel and Glaxo. In particular, I think this ground is about the Glaxo clarity and precision. Malone Friend submits that the phrase 1/3 or more is intrinsically clear. I think she said it's mathematically clear. Well, yes, it means greater than 33.3 recurring. But the same could be said if the words or more had been inserted after the word 3 in the text. The mark consists of 3 or more parallel equally spaced stripes, etc., etc. Just because the words are clear doesn't mean the sign is clear. So the maths doesn't come into this aspect of it. The issue is it's describing a multiplicity of signs, and it's the clarity of the sign that matters. And as I say, in Curly, this is put, again, I'm unable to determine exactly where it comes from, but...
Should we have a look at Curly? Because I don't think we've opened it up yet.
It's at the back end of the, or it was at the back end of the authorities before we got the full colour Babel. It's tab 21. And the footnote that Malone Friend is very keen on is footnote 51. And my Lord Justice Arnold will...
I think you were referring earlier to where they say in 2066, first of all, they say for any mark there's a degree of permissible variation.
Yes.
And they say it may well prove easier to justify permissible variation where the variation occurs in the actual use made of the mark, so it can be seen and or prove that the public see the same mark. Well, query whether that's consistent with Spear and Zinger in terms of relying upon actual use. But I think the test, would the public see the same mark, was the one you were referring to earlier.
It was, yes. And indeed, the judge observed that there was no attempt by Adidas to prove in this case that the public would see the same mark when they saw these various different depictions. So
We see from footnote 50 that they've excised the reference to distinctive characters that appeared previously.
yes, we've got that the paella has been excised from that footnote, but look, there it is. That's the way it's put in curly. I'm personally content for that to be the test. When I look at I'm not the important person. So when the judge looked at the permutation set out above paragraph 192 of the judgment, she determined that those were the public wouldn't see the same mark, and I endorse that to be the case. So the judge considered the footnote and the text of curly at the bottom of page 126, midway through 195. So, as with a lot of the criticisms at the level of the judge, I mean, she's considered all of it. She considered the cancellation division's decisions. My learned friend hasn't referred to the Board of Appeal decisions. I don't know if the court has had the opportunity to look at those Board of Appeal decisions, but they don't affirm the reasoning of the cancellation division. And in fact, they seem to take a rather interesting approach.
Since you've mentioned it, we better have a quick look, haven't we?
Yeah, it's there's a reason we haven't been to them. So the authorities bundle has the cancellation division decisions at 13, 14 and 15, and then I hope the corresponding ones are at 17, 18 and 19.
So which shall we look at?
We look at the one at 17. No, that's not the one I marked up. Actually, could I ask the court to look at 18, because that's the version I've marked up. And I think it's the tracksuit top one. Yes.
Yes.
Now, what the Board of Appeal said in my submission is that these were figurative marks, and I'm thinking in particular now, it's about paragraph 43 onwards, page 373, 374. And my reading, or if I can ask the court to read from 43 down to 47, my reading is that the sort of almost by analogy with Article 3.2 of the EU implementing regulation, they're saying that the text can never extend the scope of the pictorial representation. That's quite a bold submission, but that's my reading of these paragraphs, 43 to 47.
Right. Well, as I understand it, what you're referring to is where they say in last sentence of 47, the representation of mark prevailed over the description.
Yes, and your lordship will see. I mean, Article through.
Sorry, with what consequence?
Well,
that they disregarded the 1/3 of them.
Well, so if and insofar as there is any head scratching or confusion or puzzlement, you just bin the text and go with the pictorial representation.
But does that mean that the trademark is only valid for full-length stripe? Is that the effect of the decision?
It does. You could see that from 51.
and as a figurative mark as well.
So,
It's
so
registered
they
as a-
consider it purely on the basis of the picture.
It's registered as a picture. It's not even registered as a
Yes.
garment.
For those of us who are not as familiar
sorry.
with the figurative mark, does that just mean pictorial representation?
It's do we have a figurative mark here?
Well, I think the answer to my lady's question is yes. I mean, a figurative mark is something that's not a word, and a picture is as good a synonym for it as any.
Yes, it's a picture, but it's instead of representing a garment, you could show this figurative mark as a label, and the label would depict the garment with the full length stripe on it, or you could have it as maybe a chest badge.
Yeah.
But the point is, it's no longer depicting the garment. It's just, if you like, a logo in layman's terms, if that's
Okay.
so. It's a pretty strange construction, not very much not affirming the rationale of the cancellation division.
So they do not consider at all the 1/3 or more.
Well, they do, but they say never mind that, because the text, the pictorial representation trumps any uncertainty introduced by the description, and you'll see the Article 3.2 of the EU TMIR, so that's the EU implementing regulation, says that the description must accord with the representation and shall not extend its scope. And I would read that, I think maybe most people might read that as a prohibition. Instead, at least by analogy, because they say it doesn't technically apply, the Board of Appeal seem to be saying that no, that's a deeming provision. The description can never extend the scope. So that there's, I should say, this is under appeal as well by my clients. So my point is really that for my learned friend to be saying, oh, the judge should have taken account of these very learned cancellation division decisions. We say even the Board of Appeal didn't uphold them, and for the benefit of 2/3 of the court, decisions of the EU IPO have never been binding on the English, even pre-Brexit, have never been binding on the English courts, as distinct from the General Court and the Court of Justice. So we say that, for my own friend to say that the cancellation divisions should have been regarded as highly persuasive. We say the judge considered them and rightly, respectfully disagreed with them. And we haven't possibly had the last word on these EU TMs.
The Dutch decision.
I think the Dutch decision, I don't know what's happened to the Dutch decision. Is that under appeal? We don't know. But again, I don't think Dutch decisions have ever been binding on this court. And
Obviously not, but the question is whether the reasoning is persuasive. And it is only a first instance decision, you're right, and it could be appealed. But nevertheless, if the reasoning is persuasive, we should have regard to it.
Absolutely. And again, I don't wish to be rude about the Dutch decision or the cancellation divisions, or any more rude than I have to be. But the comparison of rigour and depth of analysis and adherence to authority, as between the decisions relied upon by my learned friend as persuasive, and frankly, on the one hand, and the judgment below, in this case, on the other, the comparison is very telling. We say that the judge below has put forward an incredibly comprehensive and careful, nuanced decision, which takes into account and attempts to apply and reconcile all of the authority, and the depth of reasoning is significantly more impressive, we say, and the grounds she gives for departing from, insofar as she was departing from, the cancellation division, the Dutch court.
She didn't have the Dutch decision because it came afterwards.
She didn't have the Dutch decision. The Dutch decision was afterwards. I'm sorry, I misspoke. The cancellation division. Of course, yes, because the Dutch decision, I think, considered or referred to the English decision.
Did it? I didn't pick that up.
Okay, well, maybe I'm getting confused
Not
with
saying you're
the
wrong.
Board of Appeal does. Well, only Junior will find whether it is referred to.
It wasn't mentioned in the paragraphs that Ms. May referred to, but it could have been mentioned elsewhere. I don't know.
I don't have a clear recollection. I apologise if I have misremembered the chronology.
I'm a little surprised by your answer in relation to the Dutch decision based upon the apparent care which went into it. This is a detailed 40-page judgment about stripes on sports kit. But how long do these decisions have to be before they attract respect?
I can see that I've gone in too hard. We would respectfully suggest that the analysis of the judge is to be preferred over the analysis of the Dutch court. I intend no disrespect to the Dutch judiciary. We say that the analysis in the relevant part of the judgments concerning validity is more detailed and
well, actually, all you need is the fact, this might be an illustration that two conscientious judges can perfectly well disagree about this sort of thing.
which feeds into the evaluative assessment point that I've made, my lord. I then propose to turn to ground 4, which is dealt with in our skeleton at paragraph 65 to 77. We've covered a lot of this ground already, but this I perceive is the ground which most centrally relates to the first requirement, the multiplicity of signs point, Mattel, Nestle. And the complaint is that the judge wrongly focused on visual differences and omitted to consider properly the impact of the origin message. Well, I think we've now removed the idea that the origin message is anything to do with acquired distinctive character or the use that's been made. We say that the complaint, as it's been developed in Malone and Friends skeleton, is that the judge didn't really consider whether or not consumers recalled one particular combination and were able to repeat their purchasing experience. But as can be seen at the end of paragraph 195, the judge did apply that very test. So I'm not quite sure what it is that the judge should have considered that the judge didn't consider, quite apart from what she said to have got wrong in relation to this. We say that it's sufficient for the multiplicity of signs that the judge reached the conclusion that the degree of variation, these were significant visual differences. And for all of the points I've made earlier about the necessity to be able to define with precision what the sign is for the purposes of double identity comparisons, it is very important to be able to, visual differences are very important. These are pictorial representations of position marks. And if and insofar as the nature of the sign itself is important, all the parties to this appeal agree that these are position marks. However, whichever box may have been ticked at the time they were applied for, under whatever regime was in place at the time, it is common ground, as it was common ground in Dyson. We say these are position marks. and therefore there must be a position. It must be a sign. It must be a position, and we say that
Sorry, I don't
these
get
are
that.
visually
Sorry,
distinct positions.
It's one thing to say that they're position marks, and as you say, that's common ground, but you seem to be drawing consequences from that, and why?
Well, it goes back to the question your lordship asked me at the beginning about, well, am I comfortable with the definition of position mark? And I broadly am comfortable with it.
Part of the reason for that inquiry is because if one's going to use terminology, it's helpful to understand what the meaning of the terms is. And I know from my own experience that the phrase position mark is commonly bandied about without it ever being defined. When you search for a definition, the only one that's readily to hand is in the EU implementing regulation, which is distinctly unhelpful. And hence my inquiry, because as I say, I have an impression, which may be fallacious, I don't know, that somehow comes from some WIPO document, but whether that's right or wrong doesn't matter. But therefore, what I was searching for was a more helpful definition of the expression, and as it happens, Ms. May has propounded what seemed to me to be a helpful definition, and you've agreed with it. And the point about that is simply so as we all know what we're talking about.
Yes.
But then you move from that of, now we know what we're talking about, does it have any actual impact on the issue in the case? And you seem to be making a submission to the effect of, this is a position mark, ergo, any degree of variation is impermissible. Now, maybe you didn't intend to go that far, but if you did intend to go that far, my question is why?
I may be no, I'm not going that far. Is the answer to your lordship's question. We're no longer trying to re-argue the point that we made below about the fact that there can't be beyond a certain quantum level variation inherent in the mark. We are here to support the judge who said that there is a permissible degree of variation. My point in relation
That's true, even if it's a position mark.
It's true, even if it's a position mark. I apologise if I overreached in the exuberance of the moment, my lord. The point I was trying to articulate imperfectly is that a position mark is for a position, and if when looking at the variations one perceives different positions, then that's not a uniform mark. That's not a sign.
Well, I think, therefore, that this comes back to the point you made earlier, which is you submit that we've got 2 degrees of variation here. We've got both the length of the stripe and also the starting and ending points. And so, therefore, you say it's not purely a question of visual differences on one of those 2 axes, it's on both of them.
My lord, yes. And that is not only the source of the ambiguity, it's also the source of the lack of uniformity in my submission, and that the multiplicity destroys the uniform perception of the position mark if that they are regarded either, frankly, as different. We decided not to call them signs, but different different visual element and or different position. It sort of ceases to be a position mark if it can be in different positions. So that's why that fundamentally is why we say the judge was right to conclude that these were significantly visually different. That this was not, these are just multiple signs, there's not variations on the same sign. And the judge explicitly applied the test about whether the consumers would see the same mark, whether they'd be able to repeat their purchasing experience, etc. and she just came to a conclusion that Adidas don't like. There was no architectural flaw in her reasoning leading up to that conclusion in my submission. I've skated over a lot of my submissions, but I think I might be done, subject to any points of clarification for the court.
No, thank you, Mr. Roberts. Thank you, Mr. No, any reply?
Yes, thank you, my lord. Just a few short points, if I may, and I'll take them in the order in which they come. So the first point was the question as to whether the case before the court below was argued by reference to condition 1 as well as condition 2, and in our respectful submission, the case was argued by reference to condition 2. That's a different point to the point that my learned friend showed the court in the pleadings and the RFI. Totally agree that the question of multiplicity or multitude of signs was a matter before the court at first instance. It obviously was. It's addressed by the judge. But where I part company with my learned friend was any suggestion in the court below that argument was being placed within the confines of condition 1 as we understand it.
Well, let's look at this the response to the request for information, shall we? So this is called bundle tab 13. And the plea we haven't been shown the particular claim, it doesn't matter, but the plea in the particular claim was, in each case, the registration in question is for an impermissible multitude of signs.
Yes.
And you ask for an explanation for that.
Yes.
And they refer to Zynga and Nestle and Cadbury. And those are the two cases I referred to earlier, argued before the same constitution, the court judgment on the same day, separate judgments. And the first and principal issue in both of those cases was condition 1. And you will see that very clearly when you look at my judgment, because my primary finding, upheld by the Court of Appeal, was non-compliance with condition 1. Non-compliance with condition 2 was only on the alternative. And then they go on, they refer to paragraph Sir John Mummery in the latter decision, subject to that decision possessed a multitude of different rules forms such that there was not an application to register a sign. Now, why is that not clearly a reference to condition 1?
All I can tell, my lord, is how it was argued before the learned judge. And it wasn't argued before the learned judge as a failure to meet condition 1. The argument before the learned judge was about condition 2.
Well, let's take it in stages. Would you accept that on this pleading, condition 1 is out to them?
Yes, of course. Yes,
right.
I
And
would.
are you maintaining your submission that they're debarred from relying on condition 1 in this court?
Well, perhaps I could just have a moment to take instructions on that. I understand the point my lord is putting to me, and I also understand the reason why my lord is putting the point to me. I have to accept, on the face of the pleading as it's written, that the point is there. Of course I do. And I also must accept that it wasn't formally abandoned by my learned friend, expressly at least, during the course of the trial. But all I can tell my lords is what happened. What happened was the case was argued by reference to the question of clarity and precision. It was argued by reference to the two aspects of the requirement of capacity for graphical representation.
Well, what Mr. Roberts said, and I would invite your comment on this, is that the two conditions were rolled up together in argument.
well, it's certainly correct that there wasn't a clear debate before the judge as to there was never a debate before the judge in the arguments as is this a condition 1 argument or is this a condition 2 argument. It just wasn't, the case just didn't proceed before her in that way. And I've got to be fair both to my learned friend and proper to the court in that the judge does acknowledge in her judgment a submission from my learned friend to the effect that the distinction between condition 1 and condition 2 may not matter. I'm just trying to find it. I'm slightly misremembering. What I'm remembering is paragraph 143 of the judgment at page 117 of the core bundle, where the judge lists out the objections, and you see impermissible multitude of forms as number 1, but it's not characterised as whether that's requirement 1 or condition 1 or condition 2.
But why is it not condition 1 when you see in 3 lack of clarity and precision? So these are 5 different objections, and of course, no doubt there's a degree of overlap. But why isn't the first one? It's not a single sign.
Well, all I can say is what I've said already. It wasn't argued before the learned judge that because it's a multitude of forms, it's therefore more than one sign and therefore falls foul of condition 1. That wasn't how the argument was put. The judge.
That seems to be the judge's finding.
The judge.
Because in several places she says it's not a single sign.
So I think my lord has in mind para 194 and 195. But of course, when you look at 195...
I was thinking more about 196. Does not correspond to a single, clear, precise, objectively ascertainable sign. One can again say, as Mr. Roberts said, well, that's rolling the two together.
Yes.
But part of it is it's not a single sign.
But when you look back in 195, in the middle of that paragraph, she says, in my judgment, on its proper reading, the public would perceive a sign, singular, which is intended to cover a wide variety of different forms.
But then she disagrees in the previous sentence with your case that it's a single sign with a limited degree of variation.
Yes, so she's addressing the variation issue and whether or not that gives the clarity and precision and the ability for the consumer to repeat the purchase. She's not addressing it as a separate question as to multiplicity under condition 1.
Yeah, well, indeed. And as I said, Mr. Roberts accepted the two conditions were rolled up together. The question remains, are they prevented from relying on condition 1?
I mean, I think the proper answer to that question is that they are not prevented because it's in their pleading.
All right, that's very fair, thank you.
But I can only be fair in terms of what went on in the court below.
The two conditions were rolled up together. We see that very clearly. Thank you.
The next point I just wanted to pick up was in relation to what the proper test is, because my Lord Justice Arnold asked my learned friend the same question that you put to me this morning, which is how to distinguish between a multiplicity of signs on the one hand and permissible variation on the other. And the only test that my learned friend could come up with is that it's an evaluative assessment, a matter of impression, and it's actually saying a question of degree. And the difficulty with that test, in my respectful submission, is that it gives no clarity or certainty as to what the law is. And so that's why the formulation that I put before my lords we respectfully suggest is to be preferred. It's the formulation where the question of whether the variation is permissible and falls the right side of the line or results in a multiplicity of different signs and therefore falls the wrong side of the line has to be assessed by reference to the two parts of the test under condition 2, namely whether the reasonable reader is able to identify with clarity and precision what the subject matter of the mark is, and whether that mark is a mark which the consumer can recall based on their imperfect recollection, so as to be able to repeat the purchase experience.
It almost seems to be replacing one question with another question. I mean, it's such a matter of judgment and impression. But there we are. I'm not suggesting you could get any closer.
No, but I suppose what I'm encouraging, the reason why I'm encouraging my test to the court is twofold. Firstly, as I say, because it's at least a test which gives other trademark proprietors, economic operators, and the registry more of an anchor by which to understand the registrability or otherwise of a mark. But it is also a test which we say we satisfy for the reasons I've already submitted to the court this morning. Though the next point I just wanted to pick up on was in relation to the question my Lord Peter Jackson put to my learned friend about the scenario where the stripe is full length, but the wording allows 5 centimetres leeway at either end. And you know, of course, I completely understand the premise of that question in terms of its ability to try and test where the dividing line might fall, and why instinctively, at least the impression I got from the way in which the question was being posed, that mark wouldn't be objectionable, whereas, of course, Thom Browne is arguing that my client's marks are. And I mean, one of the difficulties, as I think I've already submitted to the court this morning, is that by virtue of the nature of a position mark, the garment itself, as I've explained, it obviously is not part of the mark. And so whilst you see a full-length sleeve in the pictorial representation, the length of the sleeve isn't part of the mark. And you can imagine, I'm a very small person, so the length of my sleeve is going to be different to the length of my Lord's sleeve. And so a 10 centimetre difference on my sleeve may well look different to a 10 centimetre difference on my Lord's sleeve. And that's a benign example, but we say very useful because it illustrates precisely why the visual variation that's permitted by the marks in issue is not an impermissible one, because the length of the stripe, as I submitted to the court this morning, isn't part of what makes the stripe distinctive for the purposes of the origin message. And precisely because the consumer understands that as between one long-sleeved top and another, the length of the top will vary. And indeed the registration...
I know that. I mean, it's an interesting theory, but how does one know that? Got any survey evidence of consumers showing what they understand different lengths of stripe, different positionings of stripe to mean?
Well, my lord, I don't have survey evidence. We do have the acquired distinctive character evidence, which, as I explained, we say is relevant by way of a cross-check, because it's entirely consistent with the submission I've just made. I mean, obviously, the average consumer knows and understands that the length of a sleeve can vary. Necessarily, they do,
Well,
Because people
to be
come-
sure, of course, because they know the garments vary.
Right, and people come in all shapes and sizes, and in fact the registration isn't limited to a long sleeve garment. It covers a t-shirt as well, I think, from memory. So
But it might be said this increases the degree of head scratching when you look at the registration. As soon as you realise that the registration doesn't include the garment, but depends upon the garment being present, and the garment can vary as to style and size, that simply increases the degree of head scratching, doesn't it?
no, in my respectful submission, my lord, absolutely not. No, it's entirely consistent with the permissible variability because what it reinforces is the subject matter of the mark are the three stripes as they are visually represented and described in the written description, the two being consistent. That's the visual element, the sort of logo, to use my friend's word, and then the position, which is the other aspect of the subject matter of the mark, is clearly illustrated in the pictorial representation.
So this is a claim to the Platonic essence of three stripes.
No, my lord, it's a trademark for three stripes in the specific position of the outer lateral edge of the sleeve, or the side of the trouser or the short, or the side of the upper garment, depending on the mark.
Okay.
The next point I wanted to pick on very quickly was the question that my lady put to my learned friend about the sort of head scratching test. When my lady asked my learned friend, if what is it about the registrations in this case that cause someone to scratch their heads? And in my respectful submission, my learned friend didn't give a coherent answer to my lady's question. The best he could come up with was a rhetorical question to the effect that the reasonable reader will read the mark and ask themselves, well, what else can change? And we say that's precisely the problem which we encounter in paragraph 193 of the judgment, because that's where the judge also went wrong in her approach of all bets are off once you appreciate that the length of the stripes can change, and what else can change too? Well, everything can change. And so it's no answer to my lady's question to consider it in that way. And as I think the court understands, our submission is there isn't any head scratching, precisely because everyone knows what a third or more means. You know where the position is. You know, therefore, the ambit of the mark. And so then the only question is whether the visual difference within that ambit, which everyone knows what it is a visual difference which is permissible or not, whether it falls the right side of the origin function or not. Next is a small point of detail. My learned friend said that the marks which were upheld were also upheld on the same analysis and principle. But that's not quite right, because the marks which were upheld, for all of them, the judge rejected the suggestion that there was anything by way of unrepresented signs or in those marks. To the contrary, what the judge held was that the valid marks were limited to the pictorial representation. I don't know if you want to go to all the paragraphs. I can give the court a list. The relevant paragraphs are 223, 246, 253, 259, 264, 271, 277, and 282. And in each case, the learned judge rejects the submission that those marks comprise unrepresented signs, and she proceeds on the basis that those marks are limited to the pictorial representation. The next, in relation to the Dyson argument, it seems to me that there may be some confusion as to what example means. So the court understands that we accepted before the court below that the pictorial representation is an example. But it's important to understand what we meant by that and the context in which we made that, we accepted it. What we were accepting before the court was that the pictorial representation is obviously an example of the length of the stripe by virtue of the impact of the wording on the graphic representation as a whole. When you look at the pictorial representation and the wording together, it must necessarily follow from the wording, which makes clear that the length of the stripe can vary, that the pictorial representation is thereby an example, it being the full length. But that is a very different type of example to the example that was at play in the Dyson case. In the Dyson case, what Dyson themselves meant when they said that the representation, the visual representation or pictorial representation was just an example, was, as they said themselves, because what they were claiming wasn't the shape or configuration of the vacuum cleaner illustrated in that pictorial example. What they were claiming was the property of the collection bin, it being a transparent collecting bin. So it's a very different situation of what constitutes an example. And it's a point that my learned friend seems to confuse in relation to our position, and it may well be that the judge confused it too. And that's precisely why she seems to have made an error in 194 and 195, because she considers that because we accept that the graphic representation is an example, it must follow, based on Dyson and the argument that was being put forward about unrepresented sign, that our mark is necessarily falls foul of the registrability requirement. But the nature of the example that we accepted wasn't an example whereby you can ignore the pictorial representation altogether and it doesn't count for anything. It was only an example in terms of the length. The position of the stripes remain the same all the time. The nature of the stripes remain the same all the time. And the only variation that's permitted under registration is the length and therefore the start and finishing point. And that was the extent to which we conceded that the pictorial representation was an example. And that's where the error of principle we respectfully submit comes in at paragraphs 194 and 195, because the judge proceeds on the assumption that once there's an acceptance that the pictorial representation is an example, then there's no clarity or precision at all. But one does not follow from the other. And Dyson was not a decision that supports the proposition that unrepresented signs per se lead to invalidity. The last point to make is in relation to ground 4. My learned friend talked again about the permissible degree of variation, and in our respectful submission, the nature of the mark is a question which the court ought to take into account when it comes to assessing the permissible degree of variation.
And the judge expressly did so.
Indeed. And position marks, by their very nature, will permit greater variation than a word mark. A word mark is limited to the word and the word alone. But for the reasons I've explained this morning, because of the unique characteristics of a position mark, where it takes into account the logo or the visual element of the sign in conjunction with its position, but in circumstances where the product on which the position is illustrated to the reader doesn't form part of the registration, and therefore...
With this, if you have a word mark, does that mean that you've got a certain word which is yours and protected as yours?
Yes.
Whatever it might be. Does it limit you in the way in which you can then promote the word in terms of size, typeface, colour?
No. So if it is a word mark per se.
Yeah, that was what I was meaning, but I as we've discussed earlier on, trying to see whether it really matters if this is the first case about position marks, and what is so special about position marks, and whether there's anything special about them at all, just other than that it's a handy way of keeping one's thoughts in order.
Yes.
But you seem to be making the point that if you're a position mark, therefore you get some extra latitude as to where the position is, as opposed to, as you said, word marks. But could it not be said that with a word mark that you've got plenty of latitude as to how you treat that mark as well? I mean, is this a helpful initiative to try and build on what seems to me a fairly informal concept of a position mark?
I understand the point that my lord is putting to me, and there are two things to pick up and answer, if I may. The first is just in relation to a word mark. Let's say I've got a registration for the word pen, P-E-N, and it's common ground that registration will cover that word in any font, in any size, in any colour, and so that variation is inherent within the registration. So that's the first point.
Thank you.
By contrast, if I had registered the word pen in a particular font with a box around it with a colour, then that wouldn't be a word mark. That would be a device mark.
Device mark, is that
or a graphic mark. Some people call it that. Colloquially, you might call it a logo. But then, in those circumstances, it would be limited to that representation of the font and the box around it, like the Babak situation, indeed. So that the Babak mark is a device mark, not a word mark, because it's got additional elements to it beyond the word itself. So that's the answer to the first point, or the first point I wanted to make, rather, in answer to my lord's question. The second point I'd like to make in answer to my lord's question is, in my respectful submission, it is useful to consider position marks specifically, for the reasons I've explained already, namely that the garment on which the position is illustrated, or the product on which the position is illustrated, isn't part of the mark. But also it does, of course, rather depend on the granularity of the way in which you define position. And again, I think this is a point of difference between this side of the court and my learned friend, because we define the position to be the outer lateral surface of the arm. And once you understand that to be the position, then it is the same position in all of the variations of the mark. If the position is defined as only the full length of the outer lateral surface of the arm, and then you change the length, obviously you're changing the definition of the position. And so it really depends on how you define what the position is. But in my respectful submission...
Because as we discussed earlier, as part of your own definition, a position mark includes not just where it is placed on the goods, but the visual element. And if you change the visual element, even if it's in the same place, it's no longer the same position mark, is the argument.
And when my lord talks about visual element, my lord is referring to the three stripes there.
Yeah, well, let's take the familiar example of the Levi's red tab
Yes.
on the back of the jeans. So if you make it a yellow tab, it's not the same. Even if it's in exactly the same position, even if it's exactly the same dimensions.
Because part of the subject matter of that mark is the redness
Exactly.
of the label.
Yes.
That's right.
So what that tells you is it's not just a question of position, it's a question of what the visual element which you are positioning is.
Yes, and but then we come right back to the debate we've already had, which is what's the effect of why is that important? Well, it's important so that everybody knows what the scope of the mark is and what it's about, but also so that it can function appropriately as a trademark. And so that's why we're back to the question of assessing whether any whether any degree of variation within the ambit of the mark is a degree of variation which does not undermine the ability of the mark to convey a consistent origin message.
Yeah, and that's your fundamental submission.
Yes. That was all I wanted to say in reply. Apart from, I'm sorry, there were 2 points of where I slightly misspoke this morning. Very small points of detail. The first was in answer to a question my Lord Justice Arnold put about the Steele decision and whether the images of the chainsaws were before the court at the time.
Mm-hmm.
And I agreed with my lord that they weren't, because you can't see them in the reported decision. But I understand from those instructing me that they were before the court at the time, because one of the other issues before the court was a quite distinctive character.
Right, okay.
So
Thank you.
we believe that I misspoke in relation to that. And the other point of detail where I may have misspoken, I can't remember exactly what I said, was in relation to the UK specific marks in issue in this case, and the debate we had right at the very beginning as to what box you tick. We went away and checked over lunch. When the trademarks were filed, they were filed by Adidas, described as position marks, but the position mark option wasn't available. Indeed, I don't think it is still, but it certainly wasn't available at the time. And so it was the office that unilaterally put the marks into the category of three-dimensional marks.
Okay.
And again, nothing turns on it. I just didn't want to have misled the court.
No, it's good to know how things came to be as they are. Thank you.
Good. Well, thank you both, and all those who supported you in getting this appeal ready and argued so efficiently. We will take some time to consider this, and indeed you won't be surprised to hear that we won't be giving you our decision in this appeal prior to the hearing of the appeal in next week's case. Makes sense. So you'll be aware that you'll have the advantage of receiving our draft decisions in order for you to help us with any editorial corrections, please, and the agreement of a draft order. Please take care, will you, to maintain the confidentiality direction that appears at the head of the draft judgments, together with the warning as to the consequences of any breach. In a case of this sort, it's important that direction is strictly observed. We'll, having received that and approved the draft order, hand down the judgments electronically. We won't need to trouble you to come back for that. Thank you again.
All eyes available.